Tantor Audio, a division of Recorded Books, presents Against Constitutional Originalism, a Historical Critique, by Jonathan Gienapp, narrated by Josh Innerst. Introduction. History and Originalism. The infant periods of most nations are buried in silence or veiled in fable. The origin and outset of the American Republic contain lessons of which posterity ought not to be deprived. James Madison to William Eustace, July 6, 1819. Constitutional originalism is inextricably wedded to history. Ever since the provocative theory of interpretation emerged several decades ago, its core commitment that the United States Constitution should be interpreted today in accordance with its original meaning at the time of its inception has inescapably implicated historical inquiry. To know what the Constitution means, originalists claim, demands that we look to the past. Sometimes that leads inquirers to the more recent past, especially in the case of the enormously important Reconstruction amendments that were added to the Constitution following the end of the Civil War. But more often than not, it requires a deep dive into the distant 18th-century past, a return to the American founding, when the Constitution was created. While history has always mattered to American constitutional interpretation, the marked emphasis that originalism places on the past sets it apart. Nowhere else do the study of history and the practice of constitutionalism and law so directly and consequentially collide. Nowhere in contemporary American life is history more relevant or important. Originalism has taken on heightened significance of late. Thanks to the vicissitudes of recent American politics, the United States judiciary is now stacked with self-identified originalists, and for the first time in its history, the Supreme Court boasts an originalist majority. And we have already begun to see how an originalist court is liable to draw on constitutional history to radically remake modern law. Its recent appeal to the standard of history and tradition to decide a slew of landmark cases is only one of the clearest signals. In the coming years, those with the power to determine the content of fundamental American rights, to freely speak and worship, to keep and bear arms, to enjoy equal protection before the law, as well as the powers of the presidency, the legitimacy of the administrative state, and the scope of the national government's power to reform health care, address climate change, and protect voting rights, will increasingly do so by reference to history and what the Constitution purportedly meant at the time of its creation. The growing sway of originalist judges, meanwhile, has coincided with the steady entrenchment of originalism in the legal academy. Each year, the body of originalist scholarship grows, scholarship originalist judges rely on to justify their decisions. Never, therefore, has it been more important to scrutinize originalism's use of history. Originalism's engagement with history is often deeply problematic. Despite claiming to recover constitutional past as it was, most of the time, originalists create an alternative past based on the assumptions of the present. Worse, they are seldom even aware that they've done so. They confidently appeal to the early history of the United States to overturn a long-standing precedent, nullify a popular law, or protect a newfangled right, assured that they are getting things right, that they are humbly following the law as originally laid down. But they are not. They distort the very history from which they derive authority. It is past time to confront originalism's use and abuse of history. To meet this moment, this book mounts a comprehensive historical critique of constitutional originalism. It does so by approaching originalism anew. The debate over originalism has been too narrowly focused. As a result, it has skated over many of the fundamental issues implicated by the theory, issues that raise the most urgent questions about originalists' engagement with the constitutional past. In what follows, I attempt to bring these dimly appreciated issues to the surface to formulate a new critique of originalism. It is not only a critique based in history, but one that is intended to show that no critique of originalism is more fundamental than the historical one that cuts right to the theory's foundations. For too long, originalists have bypassed many of the central questions raised by their theory. For too long, they have failed to truly reckon with the history of the American founding. When we recover founding-era constitutionalism on its own terms, we discover how deeply at odds originalism is with the history it claims to recover and enforce as our fundamental law. We see how unoriginalist originalism turns out to be. Originalism's enduring focus. Among the biggest problems with originalism is the narrowness of its vision. This flaw is not rooted in what its advocates explicitly defend, but instead in what they often take for granted and leave unexplored. Most especially, when originalists probe the constitutional past in search of original meaning, their historical investigation is often strikingly narrow and limited. It is typically focused on linguistic meaning, on what the words of different constitutional provisions originally meant, and almost never on the instrument in which those words are found, the Constitution itself. What do important constitutional phrases such as executive power, freedom of speech, the right of the people to keep and bear arms, equal protection of the laws, or full faith and credit mean? In asking these questions, originalists usually assume that the Constitution's essential nature is clear and obvious, that there is little reason to worry if the Constitution as we habitually perceive, describe, and delimit it today is different from the Constitution as it was once perceived, described, and delimited back when it appeared. The Constitution simply is the Constitution, the same now and always, from 1787 to the present day. Originalists at least strive to historicize the Constitution's meaning. The entire originalist enterprise is based on the assumption that original and contemporary constitutional meaning might be different. But originalists give little thought to the prospect of historicizing the Constitution itself. They seldom wonder whether, as with the meaning of particular words and phrases, the Constitution was once understood to be a different kind of thing. Originalism's narrow focus has been one of its hallmarks, but neither its proponents nor its antagonists have much pause to examine it. This is perhaps unsurprising. It is, after all, not hard to understand why there's been relatively little attention paid to the nature of the original Constitution. The Constitution feels familiar. When we confront it, we do so with over 2 centuries of practice, precedent, and experience to draw on. We have been deeply socialized in a set of enduring interpretive traditions that shape our intuitions, organize our conversations, and channel our disagreements. Each new Supreme Court term reinforces these practices, igniting more rounds of public debate shaped by the familiar forms of argumentation and tacit assumptions that have long structured our constitutional culture. It is natural to begin where everyone else seems to start where our historical experience and collective socialization suggest we should. It is hardly surprising that people have intuitively fixated on what particular words, phrases, or clauses might mean, or have sought to trace the chain of Supreme Court precedent and doctrine, especially when most interlocutors are eager to pose the questions in those very terms. It keeps things focused and concrete, while coordinating conversation and study. It is what our evolved constitutional tradition has given us, a shared language of constitutional debate. Originalism itself emerged from debates within this particular tradition, at a specific moment in time and in response to a specific challenge. Although originalists have subsequently asserted that their theory of constitutional interpretation has been around since the founding, in its recognizable modern form, it only emerged in a much later age, during the ascendance of a liberal Supreme Court in the decades following the Second World War. Under Chief Justice Earl Warren, and later Chief Justice Warren Burger, the court dramatically expanded the scope of constitutional rights, particularly in core areas such as civil rights, reproductive rights, and the rights of criminal defendants, through controversial landmark rulings such as Brown v. Board of Education, Griswold v. Connecticut, Miranda v. Arizona, and Roe v. Wade. The Warren and Burger Court's jurisprudence was celebrated on the political left, but criticized by political conservatives angry that the court was inventing rights nowhere enumerated in the Constitution and, in so doing, exceeding its judicial mandate. Rather than interpreting the Constitution, as was their solemn charge, the justices were accused of legislating from the bench, privileging their subjective values and policy preferences over democratically enacted laws. Originalism materialized from these charged complaints about judicial activism. The term itself was not coined until 1980, and it was not until later that decade when Attorney General Edwin Meese, in a famous speech before the American Bar Association in 1985, defended a jurisprudence of original intent, and then a self-described originalist, Antonin Scalia, was appointed to the Supreme Court in 1986, that originalism cohered into a publicly identifiable theory of constitutional interpretation. But its key intellectual ingredients were forged in the preceding decades. Responding directly to the Warren and Burger Court's controversial rulings, early originalists denigrated the idea of a living constitution, something political liberals had long defended, insisting that the Constitution did not change unless formally amended. It was unlawful, originalists claimed, for judges to supersede the sovereign people and update the Constitution's meaning, to decide for themselves when society had sufficiently evolved that the Constitution meant something different than it had before. Instead, originalists argued, judges ought to treat the Constitution as dead, its meaning as fixed until lawfully changed, and focus their interpretive efforts on recovering the original intent of the Constitution's drafters. The point was less to celebrate the achievements of the Constitution's authors, even if the theory's political and rhetorical success assuredly was staked to the veneration of the American founders, than to constrain rogue judges by ensuring that constitutional interpretation would be structured by putatively neutral principles. Even if the motivations behind originalism were no doubt as political as anything its champions sought to displace, the theory was nonetheless sold as a way to take politics out of constitutional interpretation. It promised to transform a constitution that had come to be heralded for its flexibility and majestic generalities back into a set of binding rules. In the process, it would turn judges back into judges. If that was the constitutional and political moment in which originalism emerged, then the challenge the theory was devised to counter was the threat of unmoored, open-ended interpretation. Within law, originalism responded to the challenge posed by legal realism, which had first reared its head around the turn of the 20th century. Realists claimed that law was more than abstract rules judges formally applied to cases that came before them. Embedded in a set of political, social, and economic contexts, law was invariably shaped by social interests and public policy. Judges, therefore, necessarily made law as much as they interpreted it. Beyond law, however, originalism was also, more indirectly, responding to the challenge posed by the specter of radical interpretive indeterminacy, which, in the second half of the 20th century, was sweeping through several corners of intellectual life as a rising chorus of philosophers, literary critics, anthropologists, historians, and many others were emphasizing the constructed nature of meaning and interpretation. It little mattered that early originalists, like too many critics of pragmatism, post-structuralism, postmodernism, and the various other isms that unsettled them, often had only passing familiarity with the wider intellectual currents they claimed to be swimming against. Against these storms of relativism, originalism promised a formalist stronghold. As an entry in the burgeoning intellectual culture wars of the late 20th century, it vowed objectivity and neutrality in a legal and intellectual world that had purportedly lost interest in those values. For early originalists, bringing the Constitution back down to size to combat living constitutionalism, legal realism, the threat of semantic indeterminacy, and the like, entailed emphasizing its written text and the individual provisions found within. What better way to make the Constitution rule-like than to demand that people stick to the Constitution's explicit textual commands? What better way to tame the boundless readings of the First and 14th Amendments, or Congress's power to regulate interstate commerce, than to transform interpretation of those clauses into an exercise in parsing semantics and grammar and chasing after historical definitions and concrete usages? American constitutional culture had long taken written constitutionalism seriously, but originalism dramatically heightened the emphasis. As originalism evolved, the emphasis on textual provisions only deepened. For decades now, the dominant version of the theory has been public meaning originalism. Defended most conspicuously by Justice Antonin Scalia during his lengthy tenure on the Supreme Court, this form of originalism stipulates that modern interpreters are bound only by the Constitution's original public meaning, what its words would have communicated to an average reader at the time they were written, and are thus not beholden to the original authorial intentions that lay behind those words, the original purposes that might have undergirded them, or the original expected applications that were presumed to follow from them. In privileging public meaning over all else, this brand of originalism trained virtually all attention on the meaning of particular constitutional provisions. Eventually, this narrow focus came to seem obvious and natural, leaving few to wonder about the object of interpretation itself, to ask whether the Constitution, as much as the meaning of its discrete provisions, has also changed over time. Prior critiques. Ever since it first appeared, originalism has been subjected to penetrating critiques. These criticisms, many of them historical in character, others normative and jurisprudential, have tended to wage battle on originalism's terms, focused primarily on the narrower category of constitutional meaning. They go something like this. The Constitution had no single original intent or meaning, so trying to divine one is a fool's errand. The founders were as divided as we are today. Those who wrote the Constitution did not share the same goals or expect it to mean the same thing in practice. The same was true of the ratifiers who approved the Constitution in special conventions throughout the states, not to mention the vastly larger political community for whom they spoke. James Madison thought one thing, Alexander Hamilton another, Thomas Jefferson something different still. All interpreters can do is sift through and pick and choose between the multiple intents and meanings fairly contained in the historical record. In many cases, moreover, original meaning is simply unknowable. The historical evidence is insufficient, or the documentary record is silent, often because the issue at hand was never raised. In those instances in which original meaning is knowable and can be pinpointed meanwhile, it is often impossible to apply that meaning to modern circumstances unknown to the framers without updating and even changing the Constitution in the process. In many instances, this is because the Constitution's most important provisions were written in broad, general language, precisely so that they could be applied to novel circumstances in the future. This is to say nothing of the frequent complaints that originalists simplify or distort the past in their haste to find a usable past to reach their ideologically favored results. That is, that even when the original meaning of executive power, necessary and proper, freedom of speech or of the press, the right to keep and bear arms, or broader principles such as the enumeration of congressional power, state sovereign immunity, or Congress's authority to delegate rulemaking to the executive branch, can be deciphered, originalists get it wrong. Beyond originalism's historical mistakes, every bit as problematic is its core commitment that original meaning can be binding today. Originalism is illegitimate because it privileges the dead hand of the past, the understandings and agreements of generations that have long since left the scene, over those forced to live under that law today. Modern Americans are thus subject to a binding authority to which none of them agreed. To make matters worse, those earlier generations we are asked to follow tolerated, even embraced slavery, formerly excluded scores of Americans, including virtually all women, from political life, defended property requirements for voting, and violently expropriated indigenous lands. This unsavory reality severely soils the supreme democratic foundation upon which the original Constitution is said to be based. The people who breathed life into the Constitution were a woefully inadequate version of that democratic concept. We, the people of today, are not beholden to flawed 18th-century values, and instead should embrace a vision of the Constitution that looks forward as much as backward. On top of all of this, adhering to originalism would mean dismantling much of our current law, which would not only be impractical and detrimental, but would abandon hard-won progress and send us back to a benighted time of discrimination and suffering. For these reasons, the nation is better served by alternative approaches to constitutional interpretation that take constitutional growth, practice, and change as seriously as original meaning. These criticisms continue to raise vital issues, but as potent as they remain, they tend to accept originalism's narrow focus on the Constitution's discrete textual provisions. According to these criticisms, originalists are mistaken either about what is entailed in recovering the original meaning of these provisions, or whether we are bound by those meanings today. But the focus remains squarely on the meanings of specific constitutional words and phrases. It is worth pressing deeper. If we look more closely at originalism, what matters most is not how its defenders think about meaning or specifically interpret the Constitution, crucial though that is, but rather how they conceive of the Constitution itself. In focusing almost exclusively on the Constitution's meaning, originalists glide past the most vital steps in their theory, those that contemplate what it is that we are even interpreting, and ask whether that interpretive object, as we perceive it today, indeed has the same essence, identity, boundaries, and content as the one created back in 1787. We must look beneath original meaning to the original Constitution. Originalists' Constitution. When we focus on the Constitution itself, we find the bulk of the originalist argument. What originalists often presuppose about the Constitution itself, while usually obscured and seldom defended, is essential to their theory. Among themselves, originalists disagree on plenty, but by and large they reference the Constitution and its core attributes in shared, matter-of-fact ways. They often assume that the Constitution at the center of modern jurisprudence, the one that currently is debated in federal court and studied in law schools, is identical in kind to the Constitution that was created back in the 18th century. At bottom, they presume that the Constitution is a text, that its content is derived from its words, that its meaning is fixed, that the meaning of its words cannot change unless it is formally amended, and that it is a species of conventional law, that it is to be understood and interpreted like other kinds of law. The Constitution, originalists often assume, self-evidently is all of these things. What you see is what you get. The real argumentative action lies elsewhere. While originalists might not treat their assumptions about the Constitution as especially controversial, these assumptions perform foundational work. For one, originalists' arguments often depend on their just-so descriptions of the Constitution. By seeing the Constitution in a certain kind of way, originalists enable originalism to seem an intuitive way to interpret it. By emphasizing the Constitution's textual character, they make it easier to reduce interpretation to questions of linguistic meaning. By emphasizing the Constitution's legal character, they make it easier to reduce interpretation to questions of legal principle and doctrine. For another, originalists especially depend on the necessity of their assumptions about the Constitution. Originalists don't supply these assumptions, the Constitution does. They are, in originalists' eyes, given. This belief is crucial. Beneath the various normative theories that are often layered on top of it, originalism has long relied on one consistent defense, that, as an interpretive approach, it does not make a constitution, but merely finds and interprets one. This was what originalists promised the world from the beginning, a neutral theory of interpretation. Originalists have long insisted that competing theories of constitutional interpretation, especially the many variants of living constitutionalism that have long predominated, impose subjective political and moral values on the Constitution, enabling judges to pick and choose what the law ought to be on the basis of their own preferences or sense of the polity's shifting mood. Originalism, by contrast, claims merely to recover the Constitution as it is, allowing it to speak for itself. This promise is why originalism is, as one acolyte has claimed, the single, true method of constitutional interpretation. Whereas other theories get caught up in what the Constitution ought to be, originalism alone respects the Constitution for what it is. One must then still explain why any of us owe fidelity to that Constitution, but it is far easier to make that case if you have already laid claim to the one true Constitution that there is. If you establish a sharp dichotomy between judges interpreting the Constitution according to what it originally meant, and judges interpreting it according to what they think is desirable for it to mean, you have already done the work of equating originalism to fidelity. It is no exaggeration to claim that originalism's success, rhetorical and substantive, rests principally on its purported claim to merely recover the Constitution as it is. This desire to claim the mantle of objectivity best explains originalism's defining shift from original intent to original public meaning as the target of constitutional interpretation. Public meaning originalism, for several decades now the dominant version of the theory, has proved so attractive precisely because it has seemed capable of making originalism properly objective, and thus securing the theory's long-standing aim. Earlier forms of originalism, which tended to speak of recovering the founder's original intent, were vulnerable to the fact of original disagreement, and thus the problem of subjective selection. Like us, the founders disagreed, so choosing a single interpretation meant choosing one set of founders over another. But public meaning originalism seemed to offer a solution. By focusing strictly on the text of the Constitution, not what anyone thought it meant, but what its words objectively communicated at the time they were written, originalists could disaggregate the Constitution from the quirks and prejudices of its creators. No longer would originalists have to worry about adjudicating the founders' intramural squabbles. They could simply decipher the founders' objective creation, the text that had been ratified by the sovereign people. In approving the Constitution, the founding generation was, as one originalist has put it, adopting a text with an objective public meaning, which means that the content of the law, as another pair of originalists has explained, is embodied in the objective social meanings of its text, rather than in the unknowable intentions of those who voted for it. Originalists could now brush the founders' opinions to the side and tackle the supposedly straightforward empirical matter of discovering what the words of the Constitution originally meant to a hypothetical average reader at the time of enactment. By isolating the Constitution from the cacophony of founding-era voices that originally surrounded it, public meaning originalism has promised to provide the objective grounding on which the theory has always relied and claimed constitutionalism so essentially needs. Most everything originalists argue thus rests on their presumed belief that the Constitution is as they describe it, that these descriptions offer a neutral starting place for interpretation. Originalism does not, cannot stipulate an optional conception of the Constitution. By its own premises, it needs to unearth and restore the real Constitution, the one that has existed as a matter of brute, undeniable fact. Were they to admit otherwise, originalists would lose claim to their most vital arguments, and with that, the basic impetus for their theory. It is for this reason that interpreting founding-era history...
Sample complete. Ready to continue?